So, good afternoon, everyone. 안녕하세요. 만나서 반갑습니다. So, I am Ashutosh, Senior Manager at Indian Chamber of Commerce. On behalf of Indian Chamber of Commerce, I would like to extend a warm welcome to all of you. ICCK is now 12 years young and it has steadily growing membership base of around 75 members. We help to connect Korean and Indian businesses to explore mutually beneficial opportunities in addition to business and trade. We also promote and support cultural activities by working closely with Embassy of India in South Korea. As K&S Partner, our corporate member would like to introduce with several other companies who wish to gain knowledge in the patent, trademark and the copyright sector, specifically for the products and services for the Indian market. With a fast-growing economy, skilled workforce and a huge consumer base, India is high potential market for Koreans who are already doing business internationally or looking to expand overseas. The Indian market offers many opportunities, but it also comes with its own set of unique challenges. This webinar will give you the insights on IP protection in India, a legal framework, and independence of the judiciary, etc. Some important features of the trademark enforcement of trademark law with case studies for instance, civil, criminal, customs, and the trade secrets. India being more than $3 trillion economy with an expected growth of more than 8 to 9% per annum provides numerous opportunities for international companies, continuous rising in ease of doing business index, digitally revolution, innovation and startup hub, cheap labor, transparent and accountable fiscal policies are some of the factors amongst other, which makes India one of the most prominent market to cash upon. 네, 5분 뒤에 우리가 그 웨비나를 시작하겠습니다. 세미나를 하기 전에 그 세미나 시작 앞서 발표차 위에는 마이크를 모두 꺼주시기 바랍니다. 그리고 세미나 도중에 질문 있으신 경우 채팅창에서 질문을 남겨주시면 마지막 세션에 답변 드리겠습니다. 감사합니다. Thank you for joining. Before we start the seminar, please turn off your mic beside the speaker. 스피커 분께서 이어도록 하겠습니다. Over to you, Mr. Ashish.
Okay, good afternoon, everyone. My name is Ashish Chang Marbaniang, and I'm a partner in the law firm K&S Partners in India. So my presentation will be in English, but the slides will be in Korean. And so allow me to share my presentation. Give me a minute. Ashutosh, please let me know once you are able to see my screen.
Yeah, we can see your screen.
Okay. All right. So the presentation here is primarily to talk about trademarks and how it is protected in India. So just to give you kind of a flavor or an understanding of how IP protection is there in India. So to start off, it's good to understand the concept of the judiciary in India. It has an independent judiciary. It has nothing to do with the government. So the judiciary is separate from the legislative, and therefore they function independently. It has one of the most robust IP protection systems in the world. Especially India being an emerging market, it understands the importance of intellectual property and why it should be protected. So therefore, it does act as a very important, as you would say, important aspect even for investment in the country, and it understands that. So therefore, it has one of the very strong IP protection systems. The IP expertise is also very good for the reason we've got acts going back to 1940. and 1957, which makes us quite aware of the facts of the particular or the regime of intellectual property rights. The judiciary generally is pro-IP protection, and we've seen the judiciary or the judges being more protective about IP protection. In India, the judgments are primarily based on judicial precedents. So therefore, they rely on past history of cases, and they learn from what's happened in the past or previous judgments. That gives a more clarity. Instead of simply relying on a statute, the judgments actually help in interpretation of the law. And that's something that the Indian courts really look forward to it. In fact, they even rely on judgments from other countries as well to understand as to how the world is looking into that particular aspect of IP protection. There is no bias against foreign IP owners in India. It's more focused on the rights that you have, and therefore, unlike our neighbors, wherein there is an influence of protecting the residents, but here in India, it's more of protection of the law, and there is no bias against foreign IP owners. And in IP protection in India, you have, as Ashutosh has already mentioned, that we do have civil, criminal, and border remedies as well. Moving ahead. Okay, so in India, it is very important to understand that it is a common law jurisdiction, which means that registration is not mandatory. You can even obtain rights on a trademark based on your use. So in India, trademark rights can be obtained in two parts. One is by substantial usage. That means simply by using it in the commercial market, which is leading to some kind of reputation, goodwill, and that is something called common law rights. Or you can obtain trademark rights in India through registration. That is the statutory rights. You get a trademark registration under the Indian Trademarks Act. Now, the registration certificate in India is treated as the prima facie evidence of proof of ownership. So that's the only advantage which you have. Moving on. There are some features of the Indian trademark law which is very important to understand. One aspect is that the user requirement. When you apply for a trademark registration in India, you can even apply it for an intent to use basis and obtain a registration based on intent to use basis. However, you may have noticed, or you may be aware, in the United States, if you file for intent to use basis, you need to show use before even obtaining registration. That's not required in India. So you can obtain a trademark registration based on intent to use basis. And there is a non-use cancellation vulnerability period, which is 5 years, 3 months from the date of grant of registration. So if someone were to file a non-use cancellation, he can do it only after expiry of 5 years and 3 months. Coming to licensing, India also recognizes common law licensing, meaning even an unregistered mark can also be licensed in India. Also, even a registered trademark can be licensed, and it is not required to register or to apply for recordal of such license agreement with the trademark office. That is not a mandatory requirement, and even if you don't apply for trademark recordal with the trademark office, you would still have equal enforcement rights. The other part is, in India, the top left is the assignment. In assignment, if there's an assignment, there has to be two important requirements. The first requirement is that it should have a consideration amount, and it should be with, and there should be an indication that it should be with or without goodwill. This is the two important requirements in assignment. These two symbols, which is the trademark symbol and the registered symbol, this symbol can even be applied for when you have a pending trademark application. So there is no requirement, there is no prohibition on use of this symbol. However, this symbol will need to be used only if your trademark is registered in India. If you use it even before it is registered, it can be treated as a criminal offense. Then we have something called a well-known trademarks concept in India, which typically protects a particular brand across all classes of goods and services. For example, if I were to say, let's take an example for Pepsi, and someone makes Pepsi shoes or clothing. Now, as of today, Pepsi does not make clothing or shoes, but still, Pepsi would be able to take rights under this well-known trademark scheme. So in India, as we've spoken earlier, there are these remedies which can be availed of. So you have civil, you have criminal, you have border control. And these remedies, if I may just mention, is available for trademarks. But for patents, you have only civil remedy because criminal and border enforcement is not available. But for copyright, you have for all. So that's the distinction. Now we'll just talk about a bit of the criminal, civil. Just a second. So in civil remedy, there is something called interim measure. Now, when I say civil remedy, I mean filing a court case against infringement. And in this particular case, if you see, the IP owner can seek an interim injunction order against the infringement during the pendency of the suit. Because the suit is going to take many years, as the reputation is there that court cases take a long time to come to final conclusion. There is an option of filing an interim application for seeking an interim injunction. And in that interim injunction, you can ask temporary restraint of use of the trademark by the infringer. That's the prayer that you can ask for. Along with this, when you apply for interim injunction, you have to prove a good case. You have to show all the balance of convenience in your favor. So you have to show that you have a strong IP, you have a registered trademark, and the person who's used it is misrepresented, and various other factors, which from the first look of the case facts, they understand that you have a very strong case. So that's one of the requisitions that the courts look at. The interim injunction usually takes around 6 months to a year to be concluded from the date of filing of the suit. Now, moving ahead, I wanted to also talk about something called Ex-Parte Order. So in India, when you file a court case, the very next day, the court may order an ex parte injunction, which means, as most of you may know, ex parte means an absence of the defendant. So he may pass an order restraining from defendant from using the mark, even in absence of his appearance in court. Along with the ex parte order, the court can also appoint a local commissioner. The local commissioner typically is an officer of the court that visits the premise or the location of the defendant he conducts a search and then identifies the infringing material and makes an inventory, makes a list of infringing material found, quantity, what he's found, and then he kinds of seals the products and leaves it there. This is something called as a civil raid. And then the infringer is also asked to provide details of the source of the infringing products. This is another aspect when you file a court case in India, you can apply for. Coming to the next slide. So during the COVID period, there were certain initiatives that courts undertook. The first and foremost initiative the Indian courts undertook was they started having online hearing. Because of the lockdown, there was restriction of movement of public and audience. There was difficulty of service of the court papers to the defendant or defendant serving court papers to the plaintiff. Now, in those circumstances, the courts during these 2 years wherein we were undergoing this restriction, the courts have started recognizing service of court papers through email, SMS, and WhatsApp. This way, it was meant to overcome any obstacle in the proceeding. In one of the cases, in fact, in this case, which is called UTV Software Communications, a 2019 case, in this particular case, it's also very interesting what the courts did, was the Delhi High Court passed an order whereby it's called a dynamic injunction, wherein this particular defendant was hosting pirated content on its website. And when it was hosting pirated content, whenever the plaintiff went and got an injunction order, it used to then come out with another website, then another website. So as and when you get an injunction order for one website, it comes out with another website. So that's why they called it the Hydra-headed one situation, wherein every time you go to file a complaint, another one keeps coming. So the High Court in this particular case allowed the plaintiff not to file a new case, but to implement those new websites as and when they come across it. That way, the injunction order was extended to those websites as well. So moving on. Yeah. So now, what we would like to touch upon is some practical aspects of the Indian courts that you may like to know. So one is damages. Damages are available in law, but they are not frequently passed by the court. It is very minimal, nominal damages that are awarded. It's not like the US courts where they are happy to give huge damages to the defendants. India is not on that way, but there have been cases where you see that damages are started to increase. So yes, we may not be at that stage now, but we are moving towards it currently. The second aspect which we need to see is the peculiarities of the market. The infringers in India are small-time operators. They don't maintain accounting records. They don't even have financial stability to even pay you if they are counterfeiting or doing unlawful activity. So therefore, because of no accounting records, you cannot calculate the damage. So these are some aspects which are there. Unlike, and India does not have a large-scale institutional infringement. It's very rare. And as we said, interim injunction is an important milestone for any case. Considering that there's delays in litigation, if you are able to get an interim injunction against the defendant, then there is a high possibility that the defendant will come to the plaintiff and agree on some settlement terms, because then he will save his expense for engaging a lawyer or the harassment or inconvenience to attend such court hearings. So these are some practical aspects that one needs to be alive of. So this is one case which I'd like to show here. This is a case between Rainforest and Rainforest Cafe. If you see this tagline, a wild place to shop and eat, a wild place to eat. Now, if you see that Rainforest is, anyway, everyone knows, is a US food chain, and it has this tagline, a wild place to shop and eat. The defendant was actually using the Rainforest again and using the tagline, a wild place to eat. The High Court found bad faith, and because of lack of explanation of dishonest adoption, the court injuncted. So this is one case. Another case is Taco Bell. In this case, as you can see, it's an identical situation where Taco Bell, and what he did was in the bell, he's written Taco Bell, and he's used house and Mexican and Indian foods. Now, in this case, again, there was a case file and there was an ex parte injunction granted here. So this is the type of case where courts give you an ex parte on the very next day of the hearing, for the reason it is very obvious that the defendant had adopted the mark in bad faith. Now, coming to the next case, this is an interesting case, which is 7-Up, and this is 11-Up. Now, the font and style is identical, and interestingly, the red ball between 11-Up and 7-Up. Again, this was considered to be similar, and the defendant was restrained from using the mark. Here there was a situation, it's one of those cosmetic companies wherein the defendant was using the mark like Lakme, Laxmi for nail polish. The courts held that no, it is very similar. I mean, phonetically, it is very similar. Here, if you see, you can say the only difference, there is a phonetic similarity, though they could be said that structurally and visually they're different. Here, you can say that there is visual and structural similarity because there's only a difference of S. So the courts kind of considered these factors, and considering that Lakme has a very good reputation in cosmetics, they kind of passed an order restraining the defendant. This is another case which was very interesting. So here was Starbucks versus Sadarbucks. This was the real restaurant of Starbucks in India, and this is the one which was the defendant's outlet. So here the question was about similarity, the way they represented the mark. The court held that the marks were similar, and eventually there was a settlement wherein they had the defendant changed to Sadarji Baksh. So now next case, this is Dettol. I think it was a phenomenal situation around the world wherein sanitizers became a big demand when the pandemic started. Everyone was buying sanitizers. There were shortages of sanitizers. Similarly, in India, same situation. Everyone was running behind sanitizers. That meant there was great demand. With great demand comes people trying to enrich themselves because of the situation. So here was a case where this person started using Dettol for sanitizer, and the courts obviously held that they are similar and also imposed a 1 lakh cost over this as damages. Here is a very interesting case. I'll just explain to you some facts here. So in this particular case, the plaintiff, which is H&M, is the prior adopter in 2005 internationally, and defendant adopted the mark in 2011. But H&M came into India after 2011. That means even after this entity started his work or business. So the court observed that plaintiff's entry into India subsequently is irrelevant. Increased foreign travel and exchange of cultures, consumers aware of top brands world. What the court recognized here was the concept of trans-border reputation or spillover reputation. So even if supposing the mark was not used in India, there was still people's knowledge about H&M in India. And this obviously was dishonest intent to ride upon such goodwill and reputation. And the court recognized that and therefore were able to stop. So this was a case. And here was another interesting case which I thought would be relevant for all. This is a case of Zippo Lighter. Everyone knows what a Zippo Lighter is. The interesting thing about this case is that it was typically based on the shape. There was no Zippo word written on the lighter at any place. But the courts felt that the shape of this lighter is so unique and so novel, or it's only exclusively associated to Zippo company, that anyone who uses this shape will immediately think it is a Zippo lighter. And therefore the court restrained this entity from using the shape. Similarly, even colors are protected in India. So this, most of you may know that this color combination for tractors is quite famous for this plaintiff. And there was an Indian manufacturer who also started making tractors with this color combination. And that's when the court held that no, this color is unique to the plaintiff and you cannot use it. Now, this was a very interesting case, and what is very important here is that this is, everyone knows, is Mercedes-Benz, and this is something which I call a well-known trademarks protection. And this is exactly what I said. Mercedes do not make undergarments. And what they did was they used the word Benz. They made this man stand in this tricycle, tri-star symbol, and they used the phrase German perfection. It need not be restricted to mere machines or horizons. Now, because of the well-knownness of the mark, the word Benz, and the shape of this logo, the courts held that this cannot be allowed, and therefore they were restrained, even if it's unrelated. Similarly, in this case, someone adopted Sony for lungis. This is a sarong which men wear in the southern part of India. So the courts have very importantly held that even where the fields of activity in which the claimant and the defendant are engaged are remote from each other, it is possible for deception to occur if the name or mark used is highly distinctive, or if the claimant's mark or name is well known. So that's what the court observed and injuncted. Now, next case. Now I would like to talk about the criminal remedy. All which I've just discussed were civil court cases. Now I would simply like to talk about what the criminal remedies are. So there are two ways how you can actually initiate a criminal remedy. Is first, you need to file, you can file it directly to the police or law enforcement agency, or you can even approach the magistrate. Now, in the law enforcement agency, when we file a criminal complaint, you need to get the registrar's opinion as well, confirming that the particular trademark complained of is similar and is infringing. That's the confirmation they need. The reason for this requirement is typically they do not want to empower the police or law enforcement agency to have any kind of adjudicating power, considering that the law enforcement agency are an investigating body. They are simply allowed to investigate and not take action. So therefore, they have provided this kind of restriction or a requirement, a mandatory requirement to seek the registrar's opinion. Now, this requirement of an opinion is only required in relation to trademarks. No such requirement is needed for copyright. Now, when you come to the complaint before the magistrate, we always also obtain a search and seizure warrant. That's when the courts issue a search seizure warrant to the police and directs the police to investigate and even required to go and conduct a raid. Now, let me just change slide. Oops, sorry. Yes, so now in criminal cases, there's also something called a plea bargaining. So in India, what happens is once a criminal case is filed and once the FIR is registered, which is the first information report, and there is a criminal raid conducted and someone is arrested or the accused is being taken into custody, then it immediately becomes a state case. So therefore, the owner of or the complainant has nothing to do thereafter. So the court case will be state versus whoever the accused person is. The role of the complainant or the IP owner becomes limited to supporting the public prosecutor with evidence and documents for prosecuting the case. So the state prosecutor or the public prosecutor will take the case forward from there onwards. Now, like the civil court proceedings, there is an out-of-court settlement wherein you can settle the matter. In criminal matters, you can have a settlement under the concept of plea bargaining. So what happens is usually after the criminal case or criminal raids are conducted, we usually have a plea bargaining. We ask the accused if they plead guilty to the crime and they agree to certain conditions, then we can have the case closed. Now, some of the conditions that we usually agree are maybe we take an undertaking from the accused saying that you will never do it again, and we take some kind of compensation for the cost that has been incurred for filing the criminal proceedings. And we also ask them for a public apology that should be published in the newspaper. I have one example of such apology, which I'd like to read to you. If you see here, this is for one of our clients from Japan, for Yamaha. And here you would see that these are the defendants. They were arrested on May, and the case is pending before the court of so-and-so, Tisazari Court, Delhi. Accordingly, my client so-and-so, relating to the sale of counterfeit Yamaha, hereby apologize to Yamaha having its registered office in Japan and to consumers at large for dealing, manufacturing, stocking, selling counterfeit goods bearing the Yamaha marks. My client further undertakes and confirms that we will not engage in any activity which shall violate the intellectual property rights of Yamaha. So this is kind of public apology that we ask them to provide. Now, to give you some pictures of what the criminal raid looks like. So here you are. Here you would see these are the pictures of a raid. Now, what is important is the raids, when you conduct raids, it is not only primarily relating to the product, even the boxes of packaging which bear the trademark, the labels which bear the trademark, and obviously the products, all of them are also confiscated, and they are also part of the infringing material and evidence in court cases. So this is typically a photograph of the police and the investigating agencies they are making a note, and they are keeping in the police station. Now, another case which I may like to show here this is another case which we did. Again, these are for Sony, and these were see the manufacturing areas. This is where the manufacturing unit looks like. As I said, they are very small operators. They are not big operators, and very small setups. And this is how was confiscated and taken to the law enforcement office. So now I'd like to talk about, there were some issues during the COVID period, as typically the online counterfeiting issues. The problem here was that the seller on the online portal is considered to be the primary infringer, and the portal is an intermediary. So just to give you an example, you have Amazon. Now, Amazon is simply a portal, and there are lots of people selling on that portal. So the law says that the primary infringer is the person who's selling, not Amazon. So there is this section 79 of the Indian Information Technology Act, which provides immunity to the intermediary like Amazon, Facebook, and all from liability of any third-party information, data, or communication link made available by them, provided the intermediaries are able to show that the access provider of the third-party information to the communication system for its transmission or temporary storing or hosting, and as a conduit where it does not initiate transmission, select receiver, or select or modify the information. So typically what it says is it only simply provides a platform, and all the content which the seller is putting, the Amazon or intermediary has nothing to do with it. It has no control. It's not modifying or tampering with it. It's just providing a space, and in that space people are putting the information. It is not Amazon's information. Now they have a safe harbor situation, and that's a bit conditional. The conditional is that these intermediaries need to do or follow a notice and take down procedure, and they don't have to have an active participation in such offering. So if Amazon also says, yes, I confirm that they are genuine products, then that's a problem. Then that's a participation by an intermediary. But if they don't have anything of that, that's okay. So then they can avail this safe harbor provision. And these provisions were really important, which came into play very, very relevant during the pandemic, because most people stopped going to the shops, they started ordering online, and various portals started actually coming out with that. So there were some issues during the pandemic, especially while dealing with online counterfeiting issues. So the battle was against the unknown. The sellers' informations were not correct. They were giving fictitious addresses. There's a difficulty investigation because obviously there was lockdown, there was situation, difficulty of movement, and the addresses which were mentioned in the online were not fully correct. And because of all this, it was difficult to even gather evidence and even prosecute the court actions. It was difficult to even enforcing the court orders, because if the court order is against a person A, then person B starts doing. So, they keep coming up with different ways. So these were some difficulties that were felt on the online counterfeiting situation. So then there was some initiatives that were taken by the legislature. So there is this Consumer Courts Act and Consumer Protection e-commerce rules that were out. Now these rules made that e-commerce sites made some mandatory situations or conditions for e-commerce sites, wherein it made it clear that the e-commerce sites should provide all details of the product and the seller. And in case it is an imported good, then e-commerce sites should mention the name of the importer, details, and from whom that product has been imported from, and who may be the seller on the platform. And they also started maintaining record and identify sellers who have repeatedly offered goods or services that have previously been removed. And it made it also clear that e-commerce should not refuse to take back goods or withdraw or discontinue service purchased or refuse refund if paid of such goods which are found defective or spurious. Also, there was a requirement of appointment of a grievance officer. And that grievance officer is required to acknowledge any complaint which came within 48 hours and obviously take care of it within the month. Now, additionally, there was this guidelines, these rules that came out, which is called the Information Technology Intermediary Guidelines and Digital Media Ethic Rules. Now, as per this rule, it seeks to regulate 3 classes of content carriers. So one was intermediaries, the other was over-the-top video streaming platforms, and digital news media. Now, coming to the intermediaries, they were classified into 2 parts. One was a social media intermediary, and the other was a significant social media intermediary. Now, when you say significant social media intermediary, it means that an intermediary that has over 50 lakh registered users, 50 million registered users, such as in India currently there's WhatsApp, there's Facebook, Instagram, Twitter. So those would come under the significant social media intermediaries. Now, the significant social media intermediaries had a mandatory requirement to appoint 3 officers typically. One was a chief compliance officer, the other was nodal person of contact, and one was resident grievance officer. And these guys were to be available 24/7. And it's now a law that they are required to be there, and they are required to be residing in India. So you can't have someone appointed who's sitting in the United States. They have to be a person who's sitting in India. So presently, because of this whole situation, there is a challenge to this rule, which is still pending before the High Court of Delhi. So here is one case where this is between Hindustan Unilever and Endurance Domains Technology. So just to tell you, India also has its domain name registry, which is .in, .co.in, which is actually called NICSI, like .in registry, and it's called NICSI. Now, these are the guys, this is the body that actually control the functioning. Something like ICANN that controls .com, .net, .org. These are the guys in India that control .in, .co.in, .org.in, and .net.in. So if there's any domain name dispute, you can file a domain name dispute with them. And in terms of .in dispute resolution policy, something like UDRP of ICANN. So they have an INDRP. Same process, same laws which are there. Now, the question here is, in this particular case, it's a different case wherein the plaintiff was seeking that there are unknown persons that have registered fake domain names. And they were asking this body, .in registry and NICSI, to deregister or block such domain names or websites. Now, domain name registrars and the domain name registrars be blocked from granting such domain names. Today, if you want to apply for a domain name, assuming, I'm just giving an example, like ashish.com. So the domain registrar will say ashish.com is not available. Ashish with a double h.com is available. This is how it actually works. So what they're trying to do is they're trying to get an order so that domain registrar is not able to do such things. So the Bombay High Court said that the prayer which you're asking in respect of .I and .NICI cannot be granted because they are not registrars. They are simply a body that kind of controls or takes care of the ways that .in, .co.in are being handled. The direction for blocking a website can only be given to ISPs, Internet Service Providers. And the registration of the domain name is an automated process and it does not involve any human intervention. Therefore, dynamic prospective injunction against domain name registrars not to register cannot be issued. So they say even that cannot be issued. But they also held that the plaintiff has the liberty to file affidavits as and when you find any such situation. So this is one of the cases that happened in India relating to these type of situations. Now I come to very quickly, I think I've got less time, but yes, so border enforcement, this is customs recordation. You can register, as I said, trademark, copyright, geographical indications, designs. It's not meant for patents and it's only meant for imports and not exports. So you can have a recordation only for imports and not for exports. Then, second. So this is the process of registration, how it goes. So you have this website, you file it online, you get a temporary number, and then you take the hard copy and then you file it. And then the applications get rejected and applied, it gets registered. This is how it works. Just share. So now what happens is once you've got a recorder, then you have an authorized representative who's also been recorded. So whenever there is suspected goods that are being imported into India and are found to be or suspected to be infringing, authorized representative is informed. And the authorized representative is required to confirm whether it's authentic or not. If supposing you say it is not authentic and yes, this is counterfeit, then we have to provide a surety security bond, which is equal to 110% of the consignment. With that bond, you need to present a bank guarantee of 25% of the bond. And then once the proceedings will happen before the custom authorities, and if goods are found to be counterfeit, they will be destroyed, and the cost for such destruction would be given by the right holder. These are some examples of things that were being imported into India, which were not genuine and were using the trademark. And these were some customs training. We always do customs training to show that this is how you do this is how you identify. The custom officers are taught this is how you look at it, and this is how we kind of help and work together with the custom authorities in India. So quickly, I just want to second. Okay. So a trade secret, this is my second last slide. A trade secret primarily means something which is that provides a business an extra edge, a competitive edge. It's treated a way that can reasonably be expected to prevent the public or competitors from learning. It's kept in secret. And if it's gone, then the essence of the business goes away. Currently in India, there is no specific legislation to protect trade secrets or confidential information. There's no specific law. However, the protection is granted by way of contract law, by principles of equity. So whenever you do anything in India, it's always best that you have the confidentiality agreement signed, non-disclosure agreement signed, so that way you are protecting the trade secret. Just a second. So like examples of trade secret, as you can see, you have the drink Pepsi, which was introduced as Brad's drink in 1893, who made it as his drugstore where the drink was sold. It was renamed Pepsi Cola in 1898. He believed the drink was more than a refreshment, but a healthy cola, aiding in digestion, getting its roots from the word dyspepsia, meaning indigestion. He kept it as a trade secret and it remains so even today. Other examples, as you guys may be knowing, KFC, the secret recipe of 11 herbs, then Google algorithm. That's how Google is able to dominate the internet space as of today. So I think that's the end of my slide. Thank you. Let me stop sharing. Just a second, I have to stop sharing. How do... Can you help me stop sharing this, because it's
yeah, so you can in the down, you can, if you go up, like move your cursor up towards the top, and can you see?
Where is it? This one? Stop sharing.
Stop sharing, yes.
Yes, okay.
So thank you, Mr. Ashish. So I think, yeah, we are about to end this. So before that, we go ahead and take some time for the questions now. So just to remember, please be sure to type your questions into the question box in the control panel. So 혹시 질문 있으시면 그 채팅창이나 그 마이크를 켜주시면 말씀하셔도 될 것 같습니다. So yeah, I think there is no questions for now, but yeah, if we...
I mean, I'm open to...
Yeah.
I'm currently...
질문 있으신가요? Yeah, I think there is one question from Vicky Jiun Hong. If you see in the chat box, Mr.
Yes.
Ashish,
So
yeah.
I'm currently registering on Amazon. Do I need to register my brand name as a trademark? Is brand name registration mandatory in India? As I said, brand name registration is not mandatory in India. You'd be still able to enforce your rights based on your use in India. However, it is best to register it because it acts like a proof of ownership. Otherwise, you will need to show documentation to show when you first start using and all that. Thank you. So, in other words, even if you are registered in the United States, do you have to apply again in India? Trademark rights are territorial in nature, and the law says you are protected within the demographics or geographical area of your country. Therefore, even if you are registered in the United States, that registration is confined to the land of United States. it cannot come out. Though you can have, as I said, spillover reputation or transborder reputation. So for India, you would need to have the statutory right. That means the statute, the act, which is applicable only to India, for that you need to have protection and apply separately. Thank you. Santosh, you are on mute if you're saying something.
Okay, sorry. So yeah, I just wanted to say, like, it looks we have covered the question, and this, is there anything else you want to cover up before we wrap up?
You're asking me?
Yes, yes.
No, I think I've spoken too much for the time being.
Yeah, so like
I
before
think,
ending,
yeah.
yeah, definitely anything we'll receive it from the participant, we'll like mail you regarding that. So I'll just wrap
No,
up. Great,
I just would
thank
like
you.
to say one thing,
Yes,
Ashutosh, just
yes,
one thing.
yes.
Um, because India is now gearing up and becoming more virtual, so is the world because of the pandemic or any other situation. It's very important that you please see whenever you use a trademark which comes to India, it's better that you protect it and you apply for it, because it doesn't cost as much, because applying in India is not that expensive as compared to the United States or some other developed country. So therefore, it seems more important. Also, when you apply for a trademark, please also look at the domain name extensions corresponding to that particular trademark, so that you are able to even protect that as well. That's the two things, Ashutosh. Thank you very much.
Yeah, thank you. So I think that few people have like will review the material. We'll be sending these presentations in Korean and English to all the participants. And if any question comes up, I'll definitely email you through that.
Okay.
Great. Thank you, everyone. We appreciate you being here. Thanks again for joining us today, and we'll see you next time. Thank you, everyone. Kamsahamnida.
Thank you, everyone.
Thank you, Mr. Ashish.